English Shorthand Legal Dictation 120 words per minute. Start. Judgment. The first defendant, the Special Officer C1252 Arcade Cooperative Marketing Society Limited Arcade in OS number 292 of 1996 on the file of the District Municipal Court. Arcade is the appellant herein. The said suit in OS number 292 of 1996 had been filed by the first respondent herein Ponnusamy seeking permanent injunction restraining the first defendant herein appellant herein the Special Officer C1252 Arcade Cooperative Marketing Society Limited Arcade from preventing is the plaintiff right of way over the road running east-west on the southern side of the plaintiff's property and on the north side of the first defendant property and measuring 12 feet in breadth and about 200 feet in length, called Nawab David Street. By judgment dated 19/4/1999, the District Municipal Arcade decreed the suit with cost. The first defendant in the suit appellant herein then filed AS number 42 of 1999 before the Subcourt Ranipet. By judgment dated 10/12/2001, the Sub-Judge Ranipet dismissed the appeal suit with cost. First defendant in the suit then filed the present second appeal. The only substantial question of law which arises for consideration is whether the judgment and decree in the earlier suit in OS number 104 of 1995 would act as re-judicate is deciding the issues in OS number 292 of 1996 from which the present second appeal has emanated. In the plaintiff in OS number 292 of 1996, the plaintiff claimed that to the southern of his property lies the Nawab David seat and the godown of the first respondent. He claimed that the said road measuring 12 feet in the breadth and about 200 feet in the length runs east-west and has been described as a road in the plan of the second defendant, the Arcade municipality. He further claimed that the first defendant was trying to close the road by putting a fence. This had necessitated institution of the suit seeking in the relief as stated above. In the written statement of the first defendant, the facts stated that had been denied and disputed. It was specialized denied there was a road to the southern of the plaintiff's property. It had been claimed that the first defendant had earlier filed OS number 104 of 1995 before the District Municipal Court at Ranipet with respect to identical property and had obtained a degree against the plaintiff. It had therefore been claimed that the suit was barred by res judicate. The second defendant filed a written statement claiming there was a road and that the road wasted with the Arcade municipality. One of the primary issues framed by the trial court was whether the suit was barred by re-judicate in view of the judgment in the earlier suit in OS number 104 of 1995. During trial, the plaintiff examined one witness and the first defendant examined three witnesses. Both sides filed their respective title documents. The first defendant also filed as Ex B6 the report and sketch filled by the Advocate Commissioner in the earlier suit OS number 104 of 1995 and as Ex BE7 the decree copy alone of the earlier suit in OS number 104 of 1995. On analysis, the blendings and oral and documentary evidence, the trial court came to a definite finding that there was a road to the southern of the plaintiff's property, which is also evidenced by the boundary as reflected in X A1, the title deed of the plaintiff dated 17/8/1978, and in X A2, a plan for construction of the house submitted by the plaintiff and has approved by the second defendant. The title deed of the first defendant was of the year 1960. There was no road at the time. It was also found as a fact that the properties in both OS number 104 of 1995 and in the present suit were different, and that therefore the judgment in the earlier suit cannot act as res judicate. The suit was therefore decreed with cost. The first defendant then filed AS number 42 of 1997 before the subcourt at Ranipet. Again, the learned sub-judge on reappreciation of the pleadings and evidence presented found as a fact that the principle of res judicate cannot be applied in the instant case of non-suit the plaintiff. It was again found as a fact that a road, the Nawab Dewat Street, lies to the southern of the property of the plaintiff. The pleading of the second defendant that the road vested with the municipality was also noted. The appeal suit was dismissed with cost. The first defendant then filed the present second appeal. The only substantial question of law which arises from consideration is whether the judgment and decree in the earlier suit in OS number 104 of 1995 would act as res judicate is deciding the issue in OS number 292 of 1996, from which the present second appeal has emanated. In V. Rajeshwari vs. T.C. Saranabhava, reported in 2004, SSC 551, the Honorable Supreme Court had observed and held as follows. Stop.